Now, the question is very simple. At what point during a wedding can it be said that marriage has taken place? At what point during the wedding can it be rightfully said that marriage has actually taken place? Some people believe that it's at the point of the time the couples exchange vows. Oh, for better, for worse, for richer and for poverty, till death do us part, and everybody be shouting, woo! Some people also believe that it's at the point they exchange rings. When they put ring, yeah, the name of the Father, Son, and the Holy Spirit. Why you are doing all that? Why you are doing all that in church? The law, the law itself is standing on the one side, looking at you and laughing at you. Why you are busy dancing, rejoicing, clapping, jumping up and down, doing clock kicks? The law, which is the statutes, is just by the corner of the church, saying, "Oh, I don't want to perish for lack of knowledge." So, at what point during the marriage can it be said that marriage has actually taken place? Do you know that you can actually dance, jump up in church, say all the vows you can say in the world, wear one of the most expensive rings, exchange one of the most expensive rings in church, and thereafter go your way, and at the end of the day, marriage has not taken place. Marriage, in actual sense, have not taken place. And the most dangerous thing about this marriage that is contracted in a church is that the Supreme Court over time and the Court of Appeal has actually held that a marriage that is conducted in a church or in a place of worship can only qualify as a statutory marriage, or it is no marriage at all. In fact, a marriage contracted in a church cannot metamorphosize into a customary marriage, no matter the magic you want to do about it. Okay, let's say that you fail to do the right thing in the church, and you fail to contract a statutory marriage in church, and they have to now downgrade it to a customary marriage. No, it's not possible. They cannot downgrade your marriage in a church to a customary marriage. There's no magic you can make about that. The law has always been, and the court has always emphasized that the marriage you contract in a church can either qualify as a statutory marriage or it is no marriage at all. So the law is not mindful about how much you spent in your wedding. The law is not mindful about, how many dignitaries attended. The law is not mindful whether it is an archbishop or a pope that conducted the marriage. The law is mindful of, was the marriage conducted in line with the procedures set down by the Marriage Act? So what the law is mindful of. So the law is not there looking at, how much was expended, who attended, who conducted the marriage. No, the law is looking at, was the marriage conducted in line with the procedures set out in the Marriage Act? Do you understand? So it is not when you exchange rings or exchange vow that marriage took place. No, marriage actually took place at the moment when you sign Form E. And that Form E is what we're going to discuss in part of my book commentaries today. So welcome to my book commentaries today. We're still considering my book, The Church or the State Who Regulates Marriage in Nigeria. The Church or the State Who Regulates Marriage in Nigeria. So we continue today. Let's look at Form E, because the law is only mindful after you dance and jump and spray money and preach and pray and they bless you and all that. The law is still looking at you until you come and sign Form E. There's no marriage. Until you come and sign Form E, there's no marriage. That's what the law is all mindful about. So let's go to that in detail. Statutory marriage is generally proved by the production of the marriage certificate, either its original or a certified true copy of the original. The position has been solidified by the decision of the Supreme Court in the case of Osho and others, and Phillips and others. This case was reported in 1972 by the It was reported in 1972. Now, in that case, the court defined marriage certificate. The court defined how a marriage can be proved. The court actually established how a marriage can be proved in court. The court therefore proceeded, open quotation, section 32 of the Marriage Act. The court defined section 32 of the Marriage Act to be that a marriage could be proved by the production of a copy of the certificate of marriage filed in the office of the registrar. That a marriage can be proved, that the proof of your marriage is the production of your marriage certificate. The marriage certificate that was filed at the office of the marriage registrar. Now, this marriage certificate is known as Form E. Okay, so you can establish that you are married by the production of this Form E, the marriage certificate, duly filed before the marriage registrar. This means that the certificate of marriage is the prima facie evidence to prove statutory marriage under our laws. So to prove statutory marriage, you need to present your marriage certificate. You are not going to present your wedding ring. You are not going to present your reverend father or your cousins. You are going to prove your marriage by presenting your marriage certificate, which is Form E. That is how a court, and that is how it is recognized whether you are married or not. Okay? Hence, every licensed place of worship ought to issue a certificate of marriage to this couple, and such certificate must be one recognized under the law and filed in the office of the marriage registrar within the locality of the licensed place of worship. So every licensed place of worship is duty bound to issue the couples with Form E, that is the marriage certificate. What makes a place a licensed place of worship is because that place possesses Form E. Not because that place is a popular church, not because the place is has a renowned minister there. What makes a place a licensed place of worship is because that place is in possession of Form E that he will issue you after you must have danced and sprayed money. What makes that place a licensed place of worship is because at the end of all the whole celebration, they will give you Form E. So it is expected of every licensed place of worship to issue Form E to the couple at the end of the celebration of their marriage. Okay? In a situation where the church or the place of worship opted to issue its own certificate outside that statutory certificate, it is deemed that marriage has not been contracted under the law. So I've told you that what makes a licensed place of worship for celebration of marriage is the fact that it possesses Form E. So if that place of worship decided to issue you their own church certificate, Dunamis Church International, for instance, certificate of marriage, if that is what they issued you at the end of the whole dancing and spraying of money, if that was all they issued you, just be aware that there's nothing wrong with you are married under the Dunamis Church. Yes, your marriage is a Dunamis Church marriage, but under the law, you have not married. Under the law, you have not married. You are still single. You have not married. Because what the law expects of every licensed place of worship is to issue Form E to the couple at the end of the celebration of marriage. It is upon the issuance of Form E that it is said that marriage has taken place. It is upon the issuance of Form E that it is said that marriage has been contracted under the statutory law. It is important to state at this juncture that a church or other place of worship is not automatically authorized to celebrate marriage, merely because the church is registered with Corporate Affairs Commission, CAC, or because the church is a member of Christian Association of Nigeria, CAN, or a member of Pentecostal Fellowship of Nigeria, PFN, or because it's a popular place of worship. Do you see that? A church or a place of worship does not automatically qualify as a licensed place of worship just because it was registered with CAC. Doesn't automatically, it's not because the church is registered with CAC. It's not because the church is a member of CAN or PFN that qualifies the church to celebrate marriage. It is not even because the church is a popular denomination. It's not because there's a popular GO there. No, that is not what qualifies it to celebrate marriage. What qualifies a particular place of worship to celebrate marriage is because that particular place of worship is licensed under the law to celebrate marriage. And that license is not issued by CAC. The license to celebrate marriage is issued by the Federal Ministry of Interior. It is the Federal Ministry of Interior, by the hands of the Honorable Minister, that issues the license to celebrate marriage. Okay. The critical question is whether that particular place of worship where you intend to celebrate your marriage is licensed, is a licensed place of worship recognized under the Marriage Act. That's the question you must ask. This place I want to go and do my wedding, is it a licensed place of worship recognized under the Act? Okay, so now how do you recognize a licensed place of worship? How do you recognize a licensed place of worship? Okay, because we know that it's not every church, it's not every denomination that is a licensed place of worship. So how do you recognize a licensed place of worship that is authorized to celebrate marriage under the Act? Number one, demand to see the marriage license of the place of worship. Yeah, you can demand that the place of worship should show you their license. You can ask the officiating minister that, okay, please, I want to conduct my marriage in your church or your ministry, but I want to be sure that this is a licensed place of worship. Please, can I see the license of the church? Okay. Now, one of the ways to determine if the place of worship is licensed is simply by demanding to see the license issued to that place of worship by the Federal Ministry of Interior. Okay. This has nothing to do with CAC registration. They can't afford to show you the CAC registration because the registration of the church is not an issue. What you're asking to see is whether the church is licensed to celebrate marriage. So the certificate or the license they must show you must bear on it the Federal Ministry of Interior. Okay. So this has nothing to do with CAC registration or incorporation document of the place of worship. The church must satisfy you that its premises have been licensed for the purpose of celebrating marriage by disclosing its license to you and your to-be spouse. Okay, so don't go alone, you can go with your spouse, to-be spouse. Okay? So the church must satisfy you that it is duly licensed, that they are duly licensed to celebrate marriage under the law by showing you their license. Number two, ensure the license relates to that particular place of. Ensure the license relates to the particular premises. Ensure that the license shown to you relates to that particular premises. It is important to understand that a denomination might have several branches across the country. Thus, you should not assume that because a denomination has a license to celebrate marriage, it automatically qualifies all its branches as a licensed place of marriage. Now, you understand that certain denominations have their branches across the country. So don't assume that because the headquarters has license, therefore all the branches have license. No, don't assume that, please. Each of the premises, each of the branches must have its own license to celebrate marriage. Each of its branches, each of the premises of the denomination must have its own license to celebrate marriage. So the branch in Lagos, you cannot use the license of the branch in Lagos to celebrate marriage with the branch in Abuja. No, the branch in Abuja must have its license. The branch in Kaduna must have its license. The branch in Okene must have its license. So you cannot use one branch license to celebrate at the other branch. You understand? So when they show you this license, ensure that the license relates to that particular premises where you are or where you intend to celebrate your marriage. So every license issued to a place of worship is not of a general application. I've said that. It's not of a general application. The license must specify the location of the branch or venue of the place of worship where the marriage must be celebrated. For instance, if in the license it was stated that the marriage venue is Redeemed Christian Church at number 7 Yakubu Gowon Crescent, Asokoro, Abuja. Thus, if the same church, for whatsoever reason, decide to move the venue to his children's church located at number 7B Yakubu Gowon Crescent, Asokoro, Abuja, such marriage will not be recognized under the law as a statutory marriage. At best, it will be recognized as a redeemed church marriage. Another instance is that St. Paul's Anglican Church, New Nyanya, might have the license to celebrate marriage, but St. John's Anglican Church, Asata, Enugu, might not have license to celebrate marriage. I've said that this branch at New Nyanya, St. John Anglican Church, it might have license to celebrate marriage, but St. John Anglican Church, the same Anglican Church, St. John Anglican Church, Asata Enugu, might not have the license to celebrate marriage. So you must be sure that the license shown to you relates to that particular branch and to that particular premises. Now, the first example talks about if the license is to be the church location written on the license is number 7 Yakubu Gowon Crescent. The church there is located at number 7 Yakubu Gowon Crescent. If the marriage is celebrated as number 7B or number 7C or number 7I, that marriage will not be recognized as a statutory marriage because the premises where the marriage was conducted or contracted is not a licensed place of marriage. So you must put your eyes down to ensure that what is contained on the license is what is contained on the ground. Okay. Although one certificate of incorporation established the Anglican Church and all its branches in Nigeria, but one license does not empower the branches as a licensed place of worship, of course. So one Anglican Church in Nigeria has only one incorporation certificate. It has only one registration certificate. Redeemed Church, Winners Chapel, all have one certificate of registration in Nigeria. Okay? But when it comes to marriage, when it comes to licensed place of worship for marriage, each of the branches must be licensed. Each of the branches must be duly licensed before it can qualify to celebrate marriage under the law. Okay? Now, number 3, verify with the Ministry of Interior. We'll talk about the first one. We said you can demand to see the marriage certificate. Okay. Number 2, we said you can verify to ensure that the premises is the same as written on the certificate. And number 3, we said now that you can also decide to verify at the Federal Ministry of Interior. Another safest way to verify if a particular place of worship is duly licensed to celebrate marriage is to visit the office of the Honorable Minister of Interior within the location of the place of worship. So, let's say the church is located within Asokoro, Abuja. Now you have to look for the office of the Ministry of Interior that covers that Asokoro. Okay, you have to look for where the office of Ministry of Interior that covers the jurisdiction, that Asokoro jurisdiction. You have to go there because let me go ahead. The Office of the Honorable Ministers maintains an up-to-date statutory list of the licensed places of worship within its locality, and that is one of the most authentic ways to verify. The office of the Honorable Minister maintains an up-to-date. Remember, that license usually expires. The license usually expires. That is why you must demand to see it at every point in time when you want to conduct your marriage. So Mr. A cannot say, oh, I was married here in 2017 and I saw their certificate, their license, no problem, go and marry. No. You don't know if their license is still valid or if their license has been revoked by the minister. So you have to verify. You have to be sure at the particular point in time when you want to conduct your marriage, to be sure that the license of the particular place of worship is still in vogue. And one of the ways you can do that is by visiting the office of the Honorable Minister to check the registrar of the office to ensure that that particular place of worship is recognized as a licensed place of worship under the Act. Number 4, check the marriage certificate issued previously by the place of worship. Check the marriage certificate issued previously by the place of worship. If you know couples who have previously celebrated marriage at the same place of worship, it might be wise but not advisable to ask them to disclose the certificate issued to them by the said place of worship. Yeah, if you know a couple who have wedded there, say some time ago, it might be wise to ask them, okay, can I see the kind of certificate they issued you? But that is not advisable. The reason being that it is not advisable because between the time the couple married at the church and the time you are asking to see the certificate issued by the church license must have expired. But the essence of this is to ensure that the church does not merely issue church certificates. So you see why it's not advisable, because by the time you are asking, it might be that the marriage certificate, the license of that particular place of worship has expired or has been revoked. Okay, so it's not advisable to ask. But the essence of that asking is to ensure that the church is not just issuing church marriage certificates, is to ensure that the church is actually issuing Form E. Is to ensure that what was issued to that couple is exactly Form E. That is what the church is issuing. Okay, so that's the essence of asking. Okay, so the essence of this is to ensure that the church does not merely issue church certificates, church marriage certificates, as same have no value or weight of statutory marriage, as the church marriage certificate and marriage certificate under the Act are not necessarily the same. So the church marriage certificate and the Form E, that's the marriage certificate on the Act, they are not necessarily the same. A statutory marriage celebrated at a licensed place of worship must comply with the provisions of the Marriage Act to be able to confer statutory favor to the marriage contracted by the couples. Hence, the marriage certificate, hence the certificate of marriage issued after the marriage is what determines the validity of such marriage contracted. And for such certificate to be recognized under the Act, it must be filed and registered at the marriage registry. Now, it is not just enough for the church to issue Form E. It is not just enough for the church to issue you with the marriage certificate from the Ministry of Interior. It's not just enough. That same certificate issued to you must be filed at the office of the registrar. That certificate issued to you, that Form E, for it to be authentic, for it to be valid in law, it must be filed before the registrar. Section 30 of the Marriage Act provides for the church or ministry to complete and send the marriage certificate to the marriage registry, and for the marriage registrar to enter the certificate in a marriage register book. So, Section 30 of the Marriage Act mandates the ministry or the licensed place of worship to complete Form E, that is the marriage registrar, a marriage certificate, Form E, to complete Form E and forward it to the marriage registrar. The marriage registrar will then record the certificate in the marriage book. We're going to see how that is done. Let's look at how this is done in practice. Number 1, the registrar issues marriage certificate booklet to the licensed place of worship. Under Section 24 of the Marriage Act, The principal marriage registrar issues a recognized minister of a licensed place of worship with official books of marriage certificates in duplicate and counterfoils. Now, under Section 24 of the Marriage Act, after a place of worship has been licensed, the principal registrar will then issue the minister of that place of worship with a booklet of marriage certificate. Now, I told you earlier that what makes a place licensed place of worship is because that it possesses Form E. So the principal registrar will issue the officiating minister or the minister of that place of worship with the certificate booklet. Okay, so that is the first step. They issue them with certificate booklet with duplicates and counterfoils. The certificate has nothing to do with the church or the denomination. The certificate does not bear the name of the church or the logo of the church on it. The certificate can be identified with the Nigerian coat of arms and Federal Republic of Nigeria boldly engraved on it. So the certificate booklet issued to the officiating minister has nothing to do with his church or his ministry. It does not carry the name of his ministry. It does not carry the logo of their church. It bears on it the Nigerian coat of arms, and on the other corner, you will see written on it Federal Republic of Nigeria. And on the other side, you will see written on it Form E. That is what is written on it. And each of the booklets, each of the certificates in the booklet has a certificate number. The marriage certificate is also identified as Form E. It is thus expected that when a spouse approaches the licensed place of worship to celebrate their marriage, after all the dancing and prayers, the couple will be presented with their first stated certificate to sign. It is upon the signature of the couples on the certificate that it is said that marriage has duly taken place in law. So it is expected of every licensed place of worship that after the couples must have danced, you have blessed them, giving them your blessings of the church, you have prayed money and do all that you present them with the Form E, which is the marriage certificate for them to sign. It is upon the signature on Form E and upon the completion of Form E that it is said that marriage has actually taken place in law. So it's not when they warring that marriage took place. No. It is not when they exchange vow that marriage took place. It is when the couple sign and the minister completes Form E that it is said that marriage has actually taken place under the law. The signing, number 2, is the signing and witnessing of marriage certificates of Form E. The law regards your dancing. The law regards your dancing, prayers, and blessing of the couples as the celebration of the marriage. So when we say that the church is only authorized to celebrate marriage, you see what we mean? Your dancing, your preachings, your prayers, your spraying money, your recognizing visitors, all that you do, exchange of ring, exchange of vow, all of that is your celebration of marriage. That's what the law regards as celebration of marriage. And not the actual marriage in itself. Not the actual marriage in itself. Okay? A marriage is said to have occurred upon the signing and witnessing of the marriage certificate as issued in Form E by the principal marriage registrar. Okay, let me take that again. A marriage is said to have occurred upon the signing and witnessing of the marriage certificate as issued in Form E by the principal marriage registrar. Remember, Form E was issued to the minister of the church by the principal marriage registrar. So, upon the couples signing that certificate, and upon the witnesses who were there witnessing that certificate, it is upon that time that it is said that marriage has actually taken place in law. Okay? Okay. So immediately after the celebration of marriage, Section 25 of the Marriage Act mandates the officiating minister to complete the marriage certificate in duplicate and to enter in the counterfoils details such as the certificate number, date of marriage, names of the parties, that is name of the couples, and names of the witnesses. The certificate is to be signed by the officiating minister, the two parties, that is the couples, the two parties to the marriage, and at least two witnesses. Thereafter, the original copy is issued to the couple, while the duplicate copy is filed at the marriage registry. Now, this is it. After the celebration of marriage, Section 25 mandates the officiating minister to complete the marriage certificate by, filling in the details of the marriage certificate in the counterfoil provided to him by the principal registrar, and ensure that the certificate is signed by the couples, signed by the two witnesses, at least two witnesses, and signed by the officiating minister himself. After that, the officiating minister is to give the couple the original copy of that certificate, as the marriage certificate from him, issue the couples with the original copy, now takes the duplicate copy for filing at the marriage registry. Number 3 now talks about the certificate must be entered in the marriage book. The officiating minister is expected to transmit the duplicate copy of the marriage certificate of the marriage to the marriage registry within 7 days of the marriage. So it is not just after you dance and spray money, they give you certificate, you go home. Yes, you go home. That is not where marriage ends. The minister who officiated that marriage is expected to, within 7 days after that marriage, to file the duplicate copy of that certificate at the marriage registry within that locality that issued him that booklet. The officiating minister under Section 25 of the Marriage Act is expected to file the duplicate copy with the principal marriage registrar at the marriage registry. The certificate is to be, the marriage registrar must be the one, the marriage registry must be the one within the jurisdiction of the licensed place of worship. Upon receipt of the duplicate copy, the registrar is mandated under Section 30 of the Marriage Act to enter the marriage in the marriage book. So after the minister must have submitted duplicate copy to the principal marriage registrar, the marriage registrar is then expected to enter the marriage in a marriage book maintained by the registrar. Okay, it is upon entering that duplicate copy in the marriage book that is when it is fully said that a statutory marriage has taken place. Now you can practically see that the church is just like an errand boy to the state on the subject of marriage. With all due apologies to all my big churches and big like this is my own view that after examining all this, you can see that the church is just like an errand boy to the state on the subject of marriage. You can see that whatsoever the church does with regards to marriage, it does so to please the law. It does so to please the law. After all your dancing, your rejoicing, and all that, the church is still mindful of how to satisfy the law to ensure that whatever you are getting from them must have the backing of the law. See that? It does so to satisfy the law of the state. And if the church should go on its own wit and caprices to conduct marriage, such marriage will not be recognized under the law. So the church must bound itself to the law. Whatsoever the church does, it does to please the law. Because if the church should go on its own accord, it cannot produce something that you can actually tender outside there. Okay? So because when you might not understand the reason why we are taking time to discuss these subjects until when you have issues to present your marriage certificate, when you have needs, when you have needs to present your marriage certificate, maybe you want to travel abroad with your spouse, and the immigration said, oh, or the embassy said, oh, we need to see your marriage certificate, and you're going to be bringing a Mountain of Fire Movers International. That's how they be looking at it. That's how they be looking at it. So it's good you have something that you can tender out there that has a wider acceptable influence in everywhere around the world. Everywhere around the world. The moment you tender your Form E, anywhere around the world, once you tender Form E, your certificate of marriage, anywhere around the world, it is recognized. But then you go and bring your church certificate, Thunder and Fire Ministry, church marriage certificate, and you are tendering it at the embassy, they will just pursue you. They will use cane and send you home. So that is why the law has licensed certain places to celebrate marriage. And you see, the way the law works, when we say that the law licensed certain places, it looks as if the law just gives them free hand to go and be conducting marriage. No, it is still the law conducting the marriage by itself. Okay, so the law just gives you that avenue to go there because that's where you want to go and dance and spray money. Just go there, dance and spray money. After all your dance and spray money, you will still come and meet us by the corner and sign the registry. After you sign the registry, then you can now be said to have married. May I conclude this chapter with the earlier decision of the Court of Appeal in the case of Obi and others and Bosa and others. The case was reported in 2019. So it's quite an interesting case I want you to pay good attention to, because the case actually summarized everything we have discussed under this chapter. In law, as open quotation now, in law, the burden is on the appellants to prove that the ceremony which took place on the 26th of December 1970 at St. John's Catholic Parish, Ezinifite, is a valid monogamous marriage under the Act and not a mere church blessing. So the court is saying that the law is well established, that the burden to prove that the marriage this man, Mr. Obi, contracted at St. John's Catholic Parish, Ezinifite, Mr. Obi has the duty to prove that what happened at that St. John's Catholic Church is actually a monogamous marriage, is actually a statutory marriage, and not a mere church blessing. Because you can go to a church with the intention to contract a monogamous marriage or with the intention to contract a marriage under the law, but you might end up with just a church blessing and there is no marriage there. It's possible. You see, what makes marriage a monogamous marriage not because the Bible said marriage must be between one man, one wife. No, it's not because of that. Marriage is a monogamous marriage because that is what the law defined to be a marriage under the Act. So the marriage under the Act is regarded as a monogamous marriage, a marriage between one man and one wife. That is what the Act defined marriage to be, not because that is what the Bible defined marriage to be. It is the Act that says that a marriage must be between one man and one wife. So the court here is saying that for you to convince the court that what you contracted at this Catholic church, St. John's Catholic Church, is Ezinifite, the appellants have to convince the court that what happened at this church was truly a monogamous marriage. It was truly a marriage under the Act and not just a mere blessing of just what do you call it? It was not just a mere church blessing. Because you might have the intention to contract a marriage in a church, but it might end up with just a mere church blessing. In order to discharge that burden, the appellant must place before the court the evidence of the marriage as stipulated by Section 32 of the Marriage Act, which provides that, now pay attention, the court is saying that for you to convince us that what happened at this church was actually a monogamous marriage, that what happens at this church was actually a statutory marriage, you have to provide the evidence of the marriage. And you can provide the evidence of the marriage by relying on Section 32 of the Marriage Act. Now, what did Section 32 say? Every certificate of marriage which shall have been filed in the office of the registrar of any district. So section 32 is defining how you can prove your marriage, how a marriage can be proved. So number one, it said that it can be proved by every certificate of marriage which has been filed in the office of the registrar of any district. That's number one. Remember, we'll talk about that after you sign the certificate in church, the pastor or the officiating minister will give you the original. He will take the duplicate to go and file at the office of the registrar within that locality. So the court is saying that one of the ways you can prove your marriage is by producing that original that was given to you, that was duly filed at the office of the registrar. Number two, or a copy thereof purporting to be signed and certified as a true copy by the registrar of such district for the time being. So if you cannot provide the original given to you, maybe it was lost, or maybe one of your spouse refused to release it to you. If you cannot produce the original, the second option there is that you can go to the registrar and obtain a certified true copy of the duplicate that was submitted at the registry. Do you understand? It's either you produce the original copy of your certificate, or you go to the registrar where the duplicate was submitted by the officiating minister and obtain a CTC of the duplicate. And every entry in a marriage register book or copy thereof certified as aforestated shall be admissible as evidence of the marriage to which it relates. Now, these are the three ways you can establish marriage in Nigeria. You can produce the original certificate issued to you by the church, that is the Form E, or you can produce the certified true copy of the original, which is with the registrar, or you can produce the marriage book where the marriage was entered by the registrar. Although they might not give you the marriage book, you can produce the certified true copy of the marriage book or the extract of the marriage book where the marriage was entered by the registrar. These are out of these three ways. You must prove your marriage by one of these three ways to establish that you truly contracted a monogamous marriage under the Act. Okay. In any court, okay, so any of them shall be admissible as evidence of the marriage to which it relates in any court of justice or before any person having by law or consent of parties authority to hear, receive, and examine evidence. It is clear from Section 32 of the Marriage Act that marriage under the Act can be proved by one, certificate of marriage filed in the office of the registrar of the district, or a copy of the certificate signed and certified as a true copy of the certificate by the registrar. Number three, entry in the marriage register book or copy thereof certified as a true copy. So these are the three ways you can prove marriage: the original certificate, certified true copy of the duplicate, or the marriage, the register book where the marriage was entered. You can produce any of these to prove your marriage. Now, Exhibit 5, tendered as evidence of marriage between the first appellant and the deceased, is a photocopy. So, in this case, the court is saying that Exhibit 5 was tendered as a proof of this marriage, and that Exhibit 5 is a photocopy. And you cannot tender, assuming that Exhibit 5 is Form E, you cannot tender photocopy of Form E or photocopy of your marriage certificate. It's not part of the requirement listed under Section 32 of the Marriage Act. It is either you produce the original, the certified true copy of the original, or the marriage book. You cannot produce photocopy. It's not part of the requirement under Section 32. So you cannot establish your marriage by producing photocopy of a marriage certificate. But in this case, what they tendered as a proof of the marriage in Exhibit 5 is a photocopy. Let's continue. There is nothing on its face showing that it was filed in the office of the registrar, or that of the district, or that it is an
it is an entry in the marriage register book. It is not certified as true copy of any marriage certificate filed in the registrar office or as an extract of an entry in a marriage register book. The court is saying that this thing you gave us, this area exhibit 5, does not look like from E. Number one, it was not filed at the registry. Number two, it's not an extract from it doesn't look like an extract from the marriage book. It does not look like a CTC of the marriage book. Neither does it look like CTC of the Form E. That's what the court is saying. Now, in the case of Anya Ebunam, and Anya Ebunam, okay, so that's the name of this case. The Court of Appeal has to refer to this case. In the case of Anya Ebunam and Anya Ebunam, the petitioner in her amended petition approached the court for an order of judicial separation, custody of the children of the marriage, alimony pendent liens, and maintenance for herself and the children. Upon service of the petition of the respondent, he filed an application to challenge the jurisdiction of the court on the ground that marriage between him and the petitioner was a customary marriage followed by a church blessing and not a marriage celebrated under the marriage ordinance. So, in this Anya Ebunam case, the petitioner filed a petition. The respondent brought an application to strike out the petition for lack of jurisdiction. So his argument is that the marriage he had with the woman was a customary marriage with a church blessing and not a marriage under the law. So his argument before the court is that the marriage he contracted, in the real sense of it, is actually a customary marriage with a church blessing on it, and not a marriage to be taken serious under the law. So let's proceed and see. So that was his complaint. In his oral testimony before the trial court, the respondent testified that there was never a time he contracted to marry the petitioner under the Marriage Act, and no marriage certificate was issued after the church blessing. You see that? That in his mind, there's no time he planned to marry the woman under the Act. And that after the church blessed them, no certificate was issued them. Okay? So let's proceed. The respondent testified that, under cross-examination, the respondent admitted that he signed a register in the Catholic Church, but he denied that a marriage certificate was issued and he collected it. So when he was cross-examined, he admitted that he signed a register in the Catholic Church, but there was no certificate issued to him. You see that? Under re-examination, a document titled Certificate of Marriage, the content of which is similar to Exhibit 5. So remember that in this case we are dealing with, now in this case of Obi, we are dealing with, the Court of Appeal in this case is referring to another case, which is the case of Anya Ebunam, which is similar to this case we are considering. So the court is saying that in this case, during re-examination, this man said that the marriage he had was a customary marriage with a church blessing, that no certificate was given to him after the church blessing. So during cross-examination, he admitted that, he signed a register in the church, but they did not give him a certificate. During re-examination, his lawyer tendered a document through him titled a certificate of marriage. But that certificate of marriage is similar to that of the one in Exhibit 5 tendered in Obi's case, which is the case, the earlier case we are considering. Okay, let's continue. The content is similar to Exhibit 5 in this case, was tendered through him. The petitioner did not testify or call evidence and rebuttal. The learned trial judge in his ruling held that, taking all this into consideration, I do not accept that the marriage was ever agreed by the parties to be polygamous. One. So, the petitioner who brought this petition, after the man denied that there was no church certificate, there was no marriage certificate, that all he intended was just a polygamous marriage, the petitioner did not deny it. Now, the court in his ruling, in his finding, in his judgment, now held, look at what the court said. Let's look at the trial judge in his ruling held that, Taking all this into consideration, I do not accept that the marriage was ever agreed by the parties to be polygamous one. You see what the judge is saying? That in considering all these things the man said and the evidence before him, he did not intend that this man intend to have a polygamous marriage. Okay? There was a marriage, or call it church blessing, in the Roman Catholic mission between the parties in 1961. What is the effect of the marriage law? It is not in dispute that there was no registrar's certificate before the marriage, but it is my view that it cannot be disputed on the strength of the evidence before me that the petitioner and the respondent had already regarded the marriage solemnized on the 28th day of January 1961 as abatete as a monogamous marriage, which is the union of one man to one woman to the exclusion of another. That's close quotation. So the judge is saying that notwithstanding that there is no marriage certificate, that he believes that what these people intend to contract, this man and this woman, what they intend to contract was a monogamous marriage. Notwithstanding that they were not issued with marriage certificate, what they intend to contract was a monogamous marriage. That was what the judge actually found. Close quotation. The learned trial judge then referred to a number of cases and thereafter found finally as follows. These cases are quite clear, and I am of the opinion that they cover the issue in this case. The petitioner believed that she underwent a monogamous marriage, and in fact so did the respondent. His conduct in writing to the wife that she must accept the status quo and that his children were not illegitimate beliefs claims. It will be expected that if the respondent had entered into an understanding with the petitioner that their marriage was a polygamous one, he should remind her that understanding in one of his letters to the petitioner. The respondent failed to do so. On the evidence, I am of the opinion that the respondent's evidence is nothing more than a cock and bull story. I believe it. I don't agree with this learned trial judge, with all due respect. I don't agree with him. Now let's look at what the proceeding, how the case proceeds. On appeal to the Supreme Court, the court considered the provision of section 21, 24, 25, 26, and 32 of the Marriage Act. The court, per Fatai Williams, held that the only evidence adduced before the court is that of the respondent's appellant, who testified in categorical terms that what took place in the Church of the Holy Name of Mary, what took place in the Church of the Holy Name of Mary on the 28th January 1961 was a church blessing. The man testified in categorical terms that what took place in that church was a church blessing. Let's continue. And not a marriage. One would have thought that the petitioner/respondent would have produced the marriage certificate or a certified true copy thereof, or call the priest who performed the ceremony, or if the priest was not available, explain why, and then call any of the witnesses or any of those who were present at the ceremony. Instead, she offered no evidence and only put in the document, that's Exhibit 6, to which we have referred to earlier. To our mind, this document described by the person who wrote it as certificate of marriage is not in the form prescribed in Form E. The Supreme Court is saying that this man said that all he had in this Catholic church was just a mere blessing. That he didn't intend to contract a statutory marriage. That's what he's testified. And instead of this woman to go and bring their marriage certificate to rebut that argument, he did not bring any certificate. Rather, he tendered one Exhibit 6 through the man, which purportedly called itself marriage certificate. The Supreme Court is saying that on the face value of this Exhibit 6, it does not look like Form E. It is not the same thing as Form E. in the first schedule of the Marriage Act, it could not even be regarded as a public document because it is a photocopy. It is not even regarded as a public document, nor could it be described as the original or a certified copy of any certificate, entry, or record of the marriage. A marriage register was referred to in the document, but the register was not produced, nor was the failure to produce it accounted for. At best, this document contains the hearsay evidence of what somebody called Father H. Roche could have come to court to say on oath and be cross-examined by the respondent appellant. So the Supreme Court is saying that this Exhibit 6 now was supposed to be presented by that Reverend Father H, maybe the father that conducted the marriage. He was the one who was supposed to present it. So now it is just a mere hearsay because the father was not called. Although they listed the father as one of the witnesses, but they did not call the Reverend Father. Neither did the petitioner give reason why he could not call the Reverend Father. So the Supreme Court said that Exhibit 6 is at best a hearsay evidence, which the person who made it, because it is not in Form E. So it's presumed that it is the Reverend Father that made that Exhibit 6. So he was the one who's supposed to come and tender it, and he was the one who was supposed to come and give an explanation of what that document is all about, because it cannot be regarded as a marriage certificate in the same form with Form E under the Marriage Act. So it was regarded as a hearsay evidence. No reason was given why this priest was not called, as proof of marriage it is, in our view, completely lack in weight and value. So the court is saying that this, your Exhibit 6, that you call marriage certificate, although you did not call your Reverend Father to come and explain what it is, we can't regard it as a marriage certificate because it is not in the same form with Form E. Therefore, it lacks value and weight, evidential weight in law. In the absence of any rebutting evidence, we fail to see how the learned trial judge could have found as he did. You see that? I didn't agree with that learned trial judge. Because as the law is settled that a trial court cannot go on a voyage of its own findings. The trial court must consider evidence that are placed before it. That's the law. And the law is that a trial judge cannot speculate. He cannot speculate. Because what that judge did in that case was just a speculation. What the trial judge did was just a speculation. So the Supreme Court is saying that they wonder how the trial judge came to that, his finding. So let me go back to that. We fail to see how the learned trial judge could have found, as he did, that the petitioner believed that she underwent a monogamous marriage, or that the petitioner did not know at any time of the marriage, that a registrar's certificate was necessary. I don't know how the judge came to that kind of conclusion. It's just an insinuation, just a speculation. You understand? In the instant case, now back to the case we are dealing with now. Remember the Court of Appeal, we are referring to this case of, what's the name of this case again? This case of Anye Bunam. The Court of Appeal was referring to this case right from the trial to what the Supreme Court held in this case. So now back to the case at hand. In the instant case, that's the case of Obi and Bosa. In the instant case, the court below, that's the trial court, after considering the evidence led and the content of Exhibit 5, remember Exhibit 5 is the photocopy of the so-called marriage certificate. Considering the evidence led and the content of Exhibit 5 held that the fundamental raps against Exhibit 5 are that it is neither conformed to the statutory form nor was it made in compliance with Section 33 of the Marriage Act. As I hinted above, Exhibit 5 is not in conformity with the statutory Form E in the first schedule of the Marriage Act, and furthermore, I love the finding of the trial court. Actually, the trial court actually agreed that that's the Exhibit 5, purportedly marriage certificate. The trial court is saying no. Apart from the fact that it's a photocopy, it does not look like Form E. It's not in compliance with Form E as expected under Section 33 of the Marriage Act. So that's what the trial court is saying. And furthermore, Exhibit 5 is not in accordance with practice and procedure evidencing monogamous marriage in approved churches. Remember, we said earlier that for churches that are licensed place of worship, they are issued marriage certificate, that is Form E booklet, by the principal marriage registrar. Okay, so the court is saying that this USB 5 is not in accordance with the practice and procedure evidencing monogamous marriage in approved churches referred to in the Marriage Act. My summary, therefore, is that SB 5 did not establish a marriage under the Act or a monogamous marriage. The court said that, in summary, this USB 5 does not establish a monogamous marriage, neither does it establish a marriage under the Act. Okay? Okay. For this reason, the contention that any other marriage contracted by the deceased Chief Elias Chukwuemeka Chukwuma Obi in his lifetime ought to be null and void does not advance the whole truth. Now let me take that again. For this reason, the contention that any other marriage contracted by the deceased Chief Elias Chukwuma Obi in his lifetime ought to be null and void does not advance the whole truth. So the court is saying that owing to the fact that Exhibit 5 does not qualify as a marriage certificate under the Act, you cannot argue that the fact that this man, Mr. Obi, married other women, you understand? You cannot argue that the fact that Mr. Obi married other women, therefore he has gone against the law. Because under the Act, it is a monogamous marriage, one man, one wife. But in this case, this man married more than one wife. So the argument of the wife is that our marriage is a monogamous marriage. This man was not supposed to marry any other woman. So the court is saying that your argument that this man was not supposed to marry under another woman might not be totally true. We can't agree with it because the marriage you have in church was just a blessing. There's no statutory marriage in there. Because if it were to be a statutory marriage, it must be between a man, one man, and one woman. But this man married more than one wife. So the first wife cannot be arguing that it is a statutory marriage I had with him, therefore he should not have married other wives. So the trial court said, no, I don't agree with you because what you have in church was just a mere blessing and not a statutory marriage or a monogamous marriage. Okay, in my view, the finding of the court, that the Court of Appeal has resumed, in my view, the finding of the court below cannot be faulted. Exactly. The court below in this case, this particular case, cannot be faulted. Yeah, the court is right because that Exhibit 5, which is the purported marriage certificate, photocopy for that matter, does not have the same value, is not the same thing as Form E. So the trial court was right to say that it cannot be recognized as conferring a statutory marriage under the Act to the parties. So the Court of Appeal now resumed to say that, in my view, the finding of the court below cannot be faulted. The appellant did not discharge the burden of proving that the marriage which took place on the 26th December 1970 at St. John's Catholic Church Parish was a marriage under the Act. Apart from the fact that Exhibit 5 did not conform with Form E in the first schedule to the Act, and almost impairing material with the certificate in Anye Bunam case, it is a photocopy. So the court is saying that this petitioner or the petitioner did not satisfy the court, did not prove before the court that there is a genuine marriage certificate between them. Okay, and that this Exhibit 5 he tendered was the same thing in this Anye Bunam case. It does not confer statutory marriage on the parties because it does not conform with Form E. So this is to tell you that any certificate they issue to you in the name of marriage certificate must conform with Form E, must conform with the marriage certificate under the Act. Any other thing they are giving you is wash. Okay? A marriage certificate purportedly issued as evidence of a marriage under the Marriage Act is certainly a public document and not a photocopy. It's a public document, not a private document that you can get a photocopy of it. So your marriage certificate, your Form E, is a public document. And if you lose the original of it, the only way you can tender it again is by obtaining a certified true copy of it. You can't tender a photocopy of it. So you have to keep your marriage certificate very, very well, because if you lose your marriage certificate, the other way around you can get, in fact, it is waste of time photocopying it, because you can't use the photocopy to do anything. The other way you can tender your marriage certificate is by tendering the certified true copy of the certificate you have obtained from the registrar. Because the certified true copy of your marriage certificate can be obtained through the registrar within the locality where the marriage was conducted. Okay, so the court is saying that the marriage certificate purportedly issued as evidence of a marriage under the Marriage Act is certainly a public document. Only a certified true copy is admissible as evidence of such marriage. Exhibit 5 is certainly not a legally admissible evidence of marriage between the first appellant and the deceased, because Exhibit 5 is just a photocopy of what we don't even know about. Okay. Though the first appellant gave evidence that she got married to the deceased at St. John's Catholic Parish on the 26th December 1970, and photographs were taken, but the photographs were not tendered as exhibits before the court. She did not call anyone who attended or witnessed what happened in the church, who described himself as he did not call anyone who witnessed what happened in the church. PW2, who described himself as the uncle of the deceased, said he attended the traditional marriage ceremony. So they call PW2 the uncle of the deceased. He said, my Lord, all that I witnessed was the traditional marriage ceremony. He didn't attend the church one. So, traditional marriage ceremony of the first appellant and the deceased. He did not say that there was a marriage under the act between the first appellant and the deceased, or that he witnessed the ceremony in the church. So, the only reasonable witness they had, PW2, that one said that he only attended a traditional marriage, customary marriage ceremony. That was all he attended. He didn't attend any marriage or any statutory marriage at all. Now, in this case, you will see that this case failed as a statutory marriage, because what the petitioner paraded as a certificate of marriage, that's the Exhibit 5, was truly not a certificate of marriage. It was just one church, I don't know what it is, but it's not a certificate of marriage under the Act. So at best, this man's marriage is a polygamous marriage. It's a marriage under the custom. It's a customary marriage. Okay? In fact, the saving grace this case has is that somebody came and testified, PW2 came and testified that he attended a customary marriage. So that is why this marriage cannot be regarded as a customary marriage and not a statutory marriage. So the man there, the deceased, has the right to marry more than one wife, because the purported marriage that took place in the Catholic Church was never a monogamous marriage. It was never a statutory marriage. So it's just for the fact that he did a traditional marriage and someone attended and testified before the court that he attended the traditional marriage, that marriage can be qualified to be a customary marriage, wherein the man will be allowed to marry more than one wife. So in the next of my book review, I'm going to talk about customary marriage vis-a-vis statutory marriage. What happens to someone who marries under the Act? Can he marry under the custom? What about someone who marries under the customary law? Can he marry under the Act? So we're going to look at that in our next discussion of this book. Thank you so much for staying around. It's quite a discussion. Thank you so much. Please leave your likes, your comments, and most importantly, your shares behind. Thank you so much. I solely appreciate you for this. See you again in the next commentary.